My name is Darren Dinsmore, and I'm a lecturer in law here at the University of Kent, where I teach international law and international human rights law. My research interests are in conflict, emergency powers, and the role of human rights courts in dealing with systematic violations. In a book I'm completing on the Turkish conflict with Kurdish rebels in the 1990s, I examine how the European Court of Human Rights dealt with problems affecting hundreds of thousands of displaced persons. And there the court faced being flooded with claims due to a lack of local remedies. People would apply directly to the European Court. Now, in time, Turkey created a domestic compensation scheme for these people, allowing the court to close several thousand cases and send the applicants back to Turkey for redress there. And we're currently seeing something similar arise in Turkey, albeit in very difficult and different circumstances, this time in the context of an attempt to overthrow the government. The Turkish government has responded by suspending human rights guarantees in response to the failed coup. And so what I would like to discuss with you today is what limits can states place on human rights in times of crisis, and what is the role of the European Court of Human Rights in this context. Now, the failed coup of 15th of July last year made the world's headlines. There were widely shared images of soldiers surrendered beside discarded tanks on Istanbul's Bosphorus bridge. Merely hours beforehand, more than 8,000 members of the armed forces had used planes, helicopters, and armoured vehicles in an attempt to seize power of the state. In the process, they bombed the Turkish parliament, the presidential buildings, and the premises of various intelligence and security agencies. And they made an assassination attempt on the life of President Recep Tayyip Erdogan. By the time the coup was put down, 241 people had been killed and more than 2,000 people were wounded. Now, as expected, and of course, the Turkish government acted quickly. In response, it declared a state of emergency, and it claimed the need to suspend certain human rights guarantees. And that emergency remains in place today. In addition to this distinctive context, an attempt to sack the government, there are two further reasons that I want to discuss with you and examine in my research the situation in Turkey. First, there is the fact that the Turkish government has responded by adopting an extensive range of special measures and on a massive scale. And secondly, the Turkish authorities have been criticized for undermining human rights and freedoms, the functioning of democratic institutions, and the rule of law. When Turkey declared the state of emergency, it alleged that the Fethullah Gulen terrorist organization, its words, was behind the attempted coup. Now, Fethullah Gulen is a scholar, a cleric, and a leader of the Hizmet movement that owns a global network of businesses and schools, and he currently lives in Pennsylvania in the United States in exile. Now, it's worth considering the fact that in 2012, several hundred Gulenists were prosecuted in Turkey on account of their plotting to overthrow the government. And just 6 weeks before last year's failed coup in July, the Fethullah Gulenist terrorist organization, FETÖ as the Turkish government refers to it, FETÖ was listed as a terrorist organization on the basis of its infiltration of the state and plan to overthrow the government. Now, a further legal significance of this declaration, what does it mean for a state of emergency to be declared in Turkey? Well, one thing that this entails is the centralization of executive power and the ability of the executive to act by decree, that is, to take special measures to deal with the emergency without prior parliamentary debate or approval. The first decree was adopted within a week of the coup, and we have seen a total of 21 decrees adopted to date. And it's within these decrees that we see the suspension of certain human rights guarantees. Now, before examining what exactly Turkey has done, first I think it would help, and let's discuss what states can do in times of crisis, what rules apply. And of course, the first question is, under what circumstances can states derogate from their human rights obligations? And the key test is one of necessity. Is the suspension of human rights necessary to respond to an exceptional threat? And so there must be a threat that is actual or imminent, that affects the life of the nation, that affects the whole of the nation, and is such that normal measures of governance are inadequate to deal with this emergency. Now, the European Court of Human Rights has previously asserted its own competence to review whether a public emergency exists in a particular state, albeit that it defers to the assessment of the national authorities. And it has to date, it has rejected one declaration of a state of emergency, on that occasion on the basis of procedural failures by Greek colonels following the 1967 coup d'etat in Greece. Turkey has not made the same mistake with its own declaration and notification. And so with the facts of the attempted coup d'etat in Turkey and the need to secure constitutional order, it would seem that Turkey can derogate from its human rights obligations. So obviously the question is, what does this allow the government to do? What limits can it place on human rights? And what are the constraints placed on states in their choice of measures in times of emergency? Now, under the European Convention on Human Rights, some measures are out of bounds. The death penalty and torture are strictly prohibited. Beyond that, states are governed by a general rule of proportionality. That is, in dealing with the emergency, they must not go beyond what is strictly required by the exigencies of the situation. Now, that's very legal language, the exigencies of the situation, what is strictly required. So what does this actually mean? Well, in practice, we can understand what this means through a series of case law largely dominated by the United Kingdom's response to the Troubles in Northern Ireland, and more recently, its response to Al-Qaeda, and also by Turkey's measures taken during a conflict with Kurdish rebels during the 1990s. And through those cases, there has largely been a focus on detention practices and the right to fair trial. And what we saw was the European Court of Human Rights' core concern throughout has been to prevent arbitrary action in times of crisis or emergency. For instance, the court has accepted that a person may be detained for 7 days before being brought before a judge, so long as certain guarantees and safeguards are in place. And the reason for these safeguards being required, unsupervised extended detention, opens the way to torture. So the European Court of Human Rights supervises what the state is doing. And what this means for Turkey is that it will be required to demonstrate that its measures are proportionate, and it will be required to explain why those measures were applied in each individual case. And the history of the European Convention leaves us in no doubt that the court's scrutiny is critical to preventing abuse of recourse to emergency powers. States of emergency tend to involve the centralization of power and an associated reduced domestic control on executive action. But it is also the case that the European Court of Human Rights has been criticized for being too deferential to states. And Oren Gross, for instance, has argued that the court has ignored, for the most part, the phenomena of permanent, entrenched, or de facto emergencies. A state of emergency should be temporary. There should be a priority to return to normal rule. And what Gross has argued is the court has not taken a firm line in dealing with extended entrenched emergencies. So one thing that I'm examining on what remains to be seen is whether the court's response will be any more effective in dealing with this current situation in Turkey. Will the court, for instance, challenge the duration of the state of emergency? Will it recognize systematic violations, not having done so in previous emergency cases? And in fact, what of other human rights actors? Will they assist and work to ensure that the situation in Turkey is not dealt with solely by decisions of a court several years after the fact? Now let's look at the Turkish emergency decrees and just briefly examine what is it the Turkish government has done? Why is its response controversial? And when we look, there are some expected, though troubling, measures. As in Turkey's previous state of emergency in the 1990s and emergencies elsewhere, we see relaxed detention rules. So people can be held for up to 30 days before being brought before a judge, during which time their access to a lawyer can be removed for up to 5 days. Now, detention of anybody beyond 7 days would seem itself a clear violation of that person's right to liberty and security of the person. And the court will inevitably be required to carefully assess various detention practices that we're seeing in Turkey at the moment. But if we take a step back, we also see that we have more than 90,000 people being investigated and prosecuted. That is 90,000 people who are potentially subject to these special powers. And holding people for so long, involving the reduced access to a lawyer, that is what we refer to as incommunicado detention being possible, this leaves people very vulnerable to torture, something strictly prohibited. Human rights organizations such as Amnesty International and Human Rights Watch, from the beginning of the state of emergency, have claimed that there are cases of torture and ill treatment of detainees. And perhaps more surprising, the main Turkish political opposition party itself claims to have gathered 37,000 complaints of torture or ill treatment of detainees. Now, in addition to detention and torture, and perhaps what is the most, what defines the Turkish government's response the most, is the quite breathtaking mass dismissal and suspension of public servants. More than 100,000 people have been dismissed under the emergency decrees. Now, let's just think about these numbers for a moment. This includes 33,000 teachers, 20,000 members of the police, 9,000 members of the armed forces, 8,000 academics, 4,000 judges and prosecutors. And that is not all. Under the decrees, the Turkish authorities have closed private schools, universities, companies, trade unions, radio stations, television channels, and many others. So it is clear that the scale and the reach of the Turkish policy, this leaves us no doubt the ambition of the Turkish authorities in dealing with the Gulenists and bringing constitutional order and preventing the reoccurrence of the coup attempt. But these measures present an undeniable and significant threat to, for instance, the independence of the judiciary and the notion of a free media in Turkey. Now, in addition to the dismissal themselves, the fact of the dismissals, the basis on which people have been dismissed and organizations closed also runs counter to basic notions of justice. These 100,000 people that have been dismissed, they have been dismissed summarily on the basis that they have membership of, affiliation to, or connection with the Fethullah Gulenist organization. So we see a very real risk that people are being dismissed, detained and prosecuted on the basis of guilt by association. Now, further problems arise with the associated penalties. Those people who have been dismissed are banned from public sector jobs without the need for any convictions. They can be evicted from any publicly owned housing, and they and their spouses may have their passports cancelled. And lastly, it was not clear that these persons could challenge the decisions in domestic courts. There was and there is a clear and urgent need for some sort of mechanism in Turkey where these people can challenge their dismissal or suspension. This brings us to the final issue. What does all this mean for the European Court of Human Rights? Well, these decrees, it would seem quite clearly, they raise the prospect of repeated decisions of arbitrary detention, torture, various issues relating to the dismissals, and cases regarding access to a court or an effective remedy. And the scale of the challenge for the European Court of Human Rights is already clear. In 2016, the number of new applications lodged against Turkey rose by 276%. And we now see more than 12,000 pending individual cases at the European Court of Human Rights challenging Turkey's emergency measures. In addition to that, there are more than 30,000 cases lodged with the Constitutional Court in Turkey. And so the discussion at Strasbourg and at the Court of Human Rights has been how to prevent more cases, how to prevent these cases from Turkey from flooding the court. There is also the case that if you are one of these people that has been dismissed and you submit a claim to the European Court of Human Rights, even if your case is given priority, which not all of these 12,000 cases can be, it may take at least 2 years before a judgment is given in your case. And this is very important given the risk of irreversible harm by these emergency measures. 2 years may be too late. Now, what gives some cause for optimism is the very visible and concerted effort of other human rights actors and bodies to support and, in fact, to protect the court through a proactive and networked response to and direct engagement with the Turkish authorities. That is to say, the emergency is not being left to individuals taking individual claims to a court, but it is being assessed in real time, and there are signs that it is having an effect. Now, in the first instance, we have the Council of Europe Commissioner for Human Rights, Niels Muižnieks. And the Commissioner's job is to ensure that states are implementing their obligations. And the Commissioner does this by visiting and through dialogue with state institutions, MPs, and human rights defenders. And so what the Commissioner does is that he provides a direct oversight of what states are doing without waiting for individual complaints to come before the court. And Muižnieks has provided a very, very important running analysis of what measures Turkey has taken. And he has identified various problems with the emergency measures and made some very strong statements on the Turkish government response to the failed coup. While strongly condemning the coup attempt, he has criticised the lack of due process and equity in the Turkish measures. He has expressed very serious misgivings about limits on the media and the judiciary. And in fact, he has argued that when we look to the Turkish emergency measures, arbitrariness is unavoidable. Now, while the Commissioner's legal opinions have given an immediate and running response to the situation in Turkey, the Turkish government has also faced political pressure. Above the Commissioner, we have an assembly of MPs from all the 47 states that are parties to the European Convention on Human Rights. And this is a political body. And the Assembly itself has sent delegations to Turkey repeatedly through the last year since the coup. And it has placed Turkey on a special monitoring footing. And throughout its reports, the Parliamentary Assembly has called on the Turkish authorities to end the emergency as soon as possible, to stop using emergency decrees, to stop the collective dismissals of public servants, release all detained journalists, and it is called on Turkey to create a system whereby people can challenge these emergency measures. And it seems to be having some effect. The majority of the emergency decrees enacted since September last year have listed people who have been reinstated in their positions or organizations that have been reopened. 30-day pre-trial detention has been reduced to 7 days, and denial of access to a lawyer for a period of 5 days has been repealed. And we have not seen a new decree since February of this year. And finally, the Turkish authorities are creating a review commission to hear appeals for people who have been dismissed or organizations closed. And you can see this is a core part of efforts to protect the European Court from being submerged by claims from Turkey. This is something that the Commissioner and the Assembly have put an awful lot of emphasis on. Now, as yet, it is very early days for the European Court in responding to the emergency and the emergency decrees. At the end of last year, we saw 2 decisions in the cases of a judge challenging his detention and a teacher, number 26,987, on a decree list of people dismissed from office, challenging his dismissal. Now, both Zeynep Merkan and Akif Sini refer to the fact that 2 Constitutional Court judges had been summarily sacked from office, among other court staff, and the Constitutional Court in Turkey, therefore, they claimed, lacked independence and impartiality. And further, they claimed there was no means for them to appeal their dismissal in Turkey. Now, the European Court of Human Rights dismissed their claims because they had not submitted any complaints in Turkey. Their fears as to the lack of independence of the Constitutional Court were not sufficient. They were told that they must go back and apply to the Constitutional Court. And in fact, there was not yet any evidence that the Constitutional Court could not handle their complaints. Now, what muddies the waters is a Constitutional Court decision, or a series of decisions, in November last year, in which it declared that it could not review the constitutionality of the emergency decrees. Now, given that these 2 cases at Strasbourg are part of 12,000 individual complaints, and 40,000 cases have been lodged with the Constitutional Court, all eyes are on the Turkish courts and the Review Commission. For its part, the European Court of Human Rights has declared that whereas the Constitutional Court in Turkey had declared it could not review constitutionality of the emergency decrees, it remained open for individuals to challenge the emergency actions taken against them with the Constitutional Court. So all eyes are on the Constitutional Court and Turkey's Review Commission. Now, it is clear from looking at the emergency decrees and a little bit of an analysis of the European Convention on Human Rights rules on times of emergency, it is clear that the Turkish government has gone beyond what is permissible in time of crisis or emergency. In this research, I will continue to examine this networked response by various European human rights law actors and examine what is the role of the European Court in the defense of human rights in Turkey. Thank you.